Hey everybody, how's it going? And welcome back to Copper Jacket TV. So I've been waiting to make this video for a long time now. Did you know that there are over 107 different gun control laws in the state of California alone? Each one is just as bad as the other, but there is one in particular that gets abused more than any other, and one in particular that bothers more people than any other, and that is the 10-day waiting period, which in a lot of cases turns out to be an 11-day, 20-day, or even close to 30-day wait. So today we're going to be talking about that because it looks like it's at an end. Now, before we get started, I'm very excited to announce a new channel sponsor, which is Sonoran Desert Institute, SDI. I know a lot of you out there like to repair and modify your own guns. If you're looking for a way to take your hobby to the next level, Sonoran Desert Institute can help. The online programs at SDI cover armorers courses, gunsmithing, ballistics, woodworking and finishes, shooting sports management, and more, plus tools and materials shipped to your door for hands-on practice. It's never been a better time to get an education that you can actually use on the job. So what are you waiting for? Check out the link down below or call 480-999-4767 to learn more. Okay, so let's go and talk about what's going on here. And I gotta be honest, I never thought that we would see any of these major gun control laws in the state of California be overturned. And that's because the Ninth Circuit always sided with the state of California. They always used the two-step approach where the state of California proved that what they were doing was for public safety, and the Ninth Circuit would side with them over your rights, and that happened every single time. But now the interest balancing approach has been wiped away. The Supreme Court says you can't use that anymore. You have to use text, history, and tradition, which made huge changes across the country and reopened doors for things to be overturned. And that has had a major effect in the state of California. We're going to see some pretty big wins coming up here very soon in some cases like Duncan and Miller. And now we have a brand new one that has just been filed in federal court by the Second Amendment Foundation, and it's got a lot of plaintiffs with it, and now it's going after the 10-day waiting period using Bruin so that the Ninth Circuit Court of Appeals can no longer use their, state appreciated two-step approach. So this is a very major case with some really interesting arguments in it, and I want to read some of it to you guys because this to me is a clear slam dunk. The 10-day waiting period violates the Second Amendment. So just based on the test of the text itself, this will be overturned. I mean, I don't see any other way around it. The 10-day waiting period is going to be overturned by this lawsuit. So let me just go ahead and read you guys just a couple snippets from this lawsuit so you get a kind of a basic understanding of exactly what the Second Amendment Foundation and the other plaintiffs are arguing here. Now, the case is Richards v. Bonta, and if you guys want more information, I'll put a link to the article on FPC's website down below. But it says here, a right delayed is a right denied, but denying access to fundamental rights is precisely what defendants Attorney General Rob Bonta and his Director of California Department of Justice, DOJ, Bureau of Firearms, Allison Mendoza, do through their enforcement of California's unconstitutional waiting period laws that individually and collectively infringe upon the right to keep and bear arms. Now, it goes on to say typical law-abiding individuals in California cannot lawfully acquire a firearm to exercise their constitutionally protected right to keep and bear arms without first going in person to a federally and state licensed dealer, applying for the transfer of an arm, and suffering at least a 10-day ban on the possession of that arm, even when the state has confirmed, often within minutes of the application, that the person is eligible to acquire arms. Then, if the defendants affirmatively allow the transfer, the buyer must go back to the dealership to take possession of the arm no sooner than 10 days after submitting the application. And California's firearm dealers must strictly comply with the state's regulatory scheme on pain of criminal liability and loss of their license to do business. In short, defendants' enforcement of the waiting period law prevents law-abiding people from taking possession of lawfully acquired arms for immediate self-defense and other lawful purposes, even after defendants know the individual is eligible to exercise their fundamental constitutionally protected right. So basically what this lawsuit says is that a 10-day ban on your rights is still a ban on your rights. It doesn't matter if it's only 10 days. It doesn't matter if it's less than 2 weeks. It is still a prohibition on you practicing your fundamental constitutional rights, and California does not have the power to infringe on those rights under the Constitution. So just looking at the plain text of the Constitution, which says shall not be infringed, California is just violating the text on its face. Now, obviously, we have history and tradition that's going to be on our side as well, but this really comes down to just simply text, right? You do not have the right to infringe on people's constitutional rights, whether it be a day or 2 days or 10 days or 2 weeks. Now, like I said before, this is abused a lot. I have gotten multiple emails from people in the past saying, hey, I thought it was supposed to be 10 days. It's been 14 days or 24 days or whatever it is, and I still haven't heard anything back, and they're not releasing it to me, so I don't know what's going on. And so in a lot of cases, there are people out there that wait significantly longer than 10 days, and that is a massive prohibition on them trying to practice their fundamental rights. Now, one thing to keep in mind, just in case you didn't know or you're new to things, the background check comes back pretty much instantly. So they know right away whether you're qualified or disqualified. But even though they know whether you're qualified or not, that doesn't really matter. California has a cool down period. And even if you're qualified, they're going to make you wait those 10 days or more. So what they're doing is basically infringing on your rights well past the background check period, and the time that it actually takes to get that information back. So that is, again, a major infringement on your rights. And I got to be honest, this is very, very exciting. It's a very exciting lawsuit. And you could add 10-day waiting period lawsuit, which I think there's going to be a win, to the other ones like the roster being overturned, mag ban being overturned, the so-called assault weapons ban being overturned, and others that are making their way through the court system. And some of them we're going to see some results fairly soon. So it's a very exciting period, not only across the country after Bruin, but in California, who again has more laws on the books than any other state in the entire country. So again, this is a very big deal. If you guys want to read more about it, like I said before, you can find more information down below. I want to thank you all very much for watching. I really do appreciate it. Please like, subscribe, and keep up the fight.